perspective that it was an Ontario company, then in order to do substantial business in Ontario, that prong required that the securities be traded in Ontario. The courts rejected that argument. It was a trial court, then it went up to the Court of Appeals in Ontario, and then the Supreme Court of Canada did not take the case, basically denied the petition. I guess something roughly would be a denial of cert here. And the court said that by Canadian Solar having its corporate headquarters in Ontario, by Canadian Solar holding its annual meeting in Ontario, by issuing press releases from Ontario, that showed that it was conducting substantial business in Ontario, so therefore that prong was met. So what strikes me is that there will be difficulty with getting an Ontario court taking jurisdiction over a corporation where the securities neither are traded on the Toronto Exchange, nor where that company conducts substantial business in Ontario. So, you know, my reaction is that in those cases in where plaintiffs want to seek actions in Ontario, they've got to establish one of those two prongs. Now, in the Canadian Solar case, the judge did make note of the decision made in IMAX, which was a trial court. It was not a court of appeals, as I recall, with respect to this particular holding, and that is the certification of a class with respect to global treatment of both investors who traded on the Toronto Exchange and those who traded on the NASDAQ. The judge simply referred to those investors as not Canadian. How other courts will deal with that is another issue. I know the defense bar, of course, is heavily litigating that position in Canada, and how far the Canadian courts will go is to be determined. But my reaction is that you've got to show that the company's either traded on the Toronto Exchange, or else they're doing substantial business in Canada, which means that they're generally incorporated there, they are having meetings there, and or it's a facts and circumstances approach that the misstatements were triggered from Ontario. With respect to who's going to pay for this, I would think that is something, if I were a plaintiff's lawyer, that I would be concerned with. And that I would, especially if I had institutional investors, make sure that I had agreements. And I think that is where, of course, the third-party funding vehicles are crucial. That in a loser-pay situation, that if I were representing plaintiffs, and of course you do this as a matter of your livelihood, that I would have an arrangement with those plaintiffs and with the third-party funding organization to determine how those fees are going to be paid in the event that they need to be paid to the winning party if the case that I were to bring were not to be successful, and those costs were ordered.
Yeah, I don't know of a securities case in Canada with a non-Canadian plaintiff. We filed BP in Alberta with an Alberta resident because BP had connections in Alberta. They had a subsidiary. It is, as you've noted, the law varies from province to province in Canada, which causes some wrinkles. And even though substantively it might look fantastic to file in Canada, you have to look at damages. Quebec, it routinely opts out and will not participate. Toronto has a strong mechanism. Toronto actually also, with regard to funding, has a nonprofit organization based on the premise that funding this kind of class action is in the best interests of Canadian plaintiffs, and you can apply for that kind of funding for loser pays. Loser pays also varies from province. So in Alberta, which is kind of cool, it's loser pays only on each individual motion. So if you bring a motion for class cert and the defendants oppose it, they pay for their loss, which I actually really like conceptually as a mechanism because it means a lot less meaningless motion work and fewer fees. Ontario works the other way, sort of the standard loser pays, which requires a bigger insurance mechanism, which they have then provided via this nonprofit. But in the BP case, the judge called a meeting of plaintiffs' lawyers ex parte with office, very, you know, Alberta's the Texas of Canada, they say, and said, you only have an Ontario, sorry, we didn't have an Alberta plaintiff, you only have an Ontario plaintiff, I don't think there's enough connection here, and I'm sending this case over to Ontario unless you show up with a plaintiff. The other piece that is true in terms of developing cases there's extreme antipathy toward U.S. attorneys, which I understand. Why would that be? This misperception that plaintiffs' lawyers make all the money. I just want to say I have made many defense lawyers millions and millions of dollars over the years. But what that means is there is, just as to who is the lawyer standing up and representing the plaintiff, really turns on whether it's a Canadian lawyer. And there's a fair amount of discrediting that occurs when it might appear that, for example, a firm such as Siskins might have a financial backer, such as Robbins Geller. I'm not saying that's true, but it could be true. That there is that sort of mechanism that's also going to come to play, I think, with the success of Canadian class actions. But I do agree that it's substantively more favorable, and it does. You raise the same question, which is, what do U.S. investors do when they are foreclosed in the decisions here? How do we recover in Canada or anywhere else?
Frank, I want to get the language of the statute, so I'm just not paraphrasing. In order for a party to be a responsible issuer, talking about the company, it must be a reporting issuer, number one, which means that it's had an offering and that it's periodically reporting with the Ontario Securities Commission, just like a publicly held company here reports quarterly and annually with the SEC. So that's the first category. The other is any other issuer with a real and substantial connection to Ontario whose securities are publicly traded. So the reason that there was that jurisdiction over Canadian Solar was that even though its securities were not publicly traded in Ontario, and publicly traded under the Ontario Securities Act means publicly traded in the Ontario Securities Act means publicly traded anywhere. That's what the court held. And that the court held that even though Canadian Solar was not a reporting issuer under Ontario law, nonetheless it did have a real and substantial connection to Ontario based upon those acts that I mentioned.
Thank you. Okay, Joe, and then we'll take a break, although the conversation can't continue over lunch because we have no lunch program except lunch.
Just very quickly on France, where we blessedly do not yet have class actions. The who pays question is in fact one of the issues. The government is proposing. Well, the government has proposed a bunch of different times and failed to adopt legislation over the last 20 years. The current government, refrain from making political comments, is proposing once again to come up with something, and the stumbling block is pays. We actually, although Mark has said we have a loser pay system, it's like one of the Netherlands, where in fact it's totally the discretion of the court, and it's usually a tiny fraction of whatever it is, but they still have the problem of, if we have a loser pay system, how are we going to do that in the case of a class action? And that's a real stumbling block.
So I have a question. Is this tiny fraction rule predominant throughout the civil system? Because
it's in Germany too.
Yeah.
And there they have the benefits that often the court will set it in advance. They'll set the case value.
Yeah, but Germany has legislation about it. We have a thing that says it is up to the discretion of the courts to award they're called legal fees, but they're not. You can't even submit bills to show how much you had your lawyers charged you. The highest I've ever seen was in a $75 million case, $250,000 in fees, and most of the time,
which is already big money.
Which is already, that's huge, and most of the time it's 10, 15, 20,000 euros.
So actually, the plaintiff is paying their own attorneys, and
Absolutely.
But are contingent fees that generally unethical?
Unethical.
That's right.
There is there's a no-win-no fee, which is not no cure, no pay, but they interpret that you can accept to start working for a lower fee and then at the end get some more. They refer to the Dutch Bar Association refers to it in English as a no-win-no fee, which I find misleading. But at least that's something completely different from no cure, no pay. That's strictly forbidden.
They might like blended fee better.
Yeah.